Conveyancing Forum 2026, February 2026. Crikey, where's life going? Can someone stop the world for a little while so I can have a rest? Delighted to say once again, this event is sponsored by our dear friends at Stewart Title, and I'm over the moon to introduce you, Mr. Wes Timothy, all the way from Cheshire, who's a new recruit at Stewart Title. Welcome, Wes. Thank you for coming along today. And that scamp Robert Kelly, Wes, I never really liked. I don't think he does very good presentations, etc. So I'm delighted that you're here to take over. So I'm happy if that's all right with you to look after the slides. And Wes, if you could say a few words about your work and what Stewart Title is all about, that would be a fantastic introduction to today's forum.
I'd love to. Thank you, Ian, and I'll pass on your sentiment to Mr. Kelly when I speak to him. Yeah, so as it said, I'm Wes Timothy. I'm a senior underwriter at Stewart. I've done the rounds in the business. I've been at a couple of places before, so hopefully I might have come across some of you in those travels. But I'm here settled at Stewart now and very pleased to be there. A great bunch of people. So I'm not going to speak for too long because I know you just want to hear to listen to Ian, but just a note on our online system solution, and thank you to all of those that you may use it. If you don't, please do give it a go. There's just some headlines on the screen in front of you now. So we cover up to 20 million. I've got numerous policies available for you to meet most of your needs, as well as being supported by a great team of underwriters behind the scenes if you need us. There's some changes afoot on that, and hopefully we're going to make it a much better proposition for you going forward too. So we're delighted to be sponsoring and being involved in sessions such as this, particularly with the great Ian Quayle. We all know him well, don't we? Yeah, I think that's probably enough for me, to be honest. If you do want to get in touch, there's some information on the screens there. We'll be delighted to see any business from you. So I'll leave it to you now, Ian, to get going with the nitty-gritty.
Thanks, Wes. Wes, thanks very much. Good to hear from you, and welcome aboard, and look forward to working with you. Ladies and gentlemen, so we've got lots of things to talk about today, loads of things, to be honest with you, lots of things happening, lots of things to talk about. First of all, the sort of demise of PM law, very sad news for everyone, but some interesting sort of things with regard to that, really. And, you know, it's just the sort of fallout from their sort of collapse or demise and how sad that's been. I noticed that a lot of former employees have been able to get work, which is good to hear. Devastating to hear some of the problems that clients have had with regards to matters that have sort of been left high and dry with, which is awful. But hopefully things are getting resolved in that connection, and that new clients are finding new homes, and I'm sure conveyancers are doing the best to get things rolling again, which is good to hear. As usual, when I start presentations such as this, I mention websites. Yesterday, I was getting the train home from London back up north, and I was sitting on the train, and as I do, I had a look at Tanfield Chambers' website. Really interesting articles. I put something on LinkedIn this morning. One about sort of good faith clauses generally, written by my friend Andrew Butler Casey, taking you through all the case law with regard to good faith clauses, and looking at it from all manner of different perspectives, including the perspective of property lawyers. Also, a really interesting case law report concerning the interpretation of articles of association of a management company. Again, details on LinkedIn, or you could have a look at Tanfield Chambers' website. I also regularly look at Falcon Chambers. I don't know if you've looked there, but that's worth a look at as a conveyancer, because there's always articles and interesting updates in connection with case law, etc. I mentioned some of the websites on slide there. Property Law UK is our publication. The February edition is due out next week. Loads of interesting stuff in there. I think there's over 100 pages of articles, case law reports, etc. If you haven't had the chance to see that, have a look at it. It's great, really interesting reading. So again, the rest of the stuff on there you're probably familiar with, so I needn't sort of bore you by going through them. What I want to do is talk about topics today. However, remember, this is your forum. So I am more than happy to explore other issues or anything else that you want to talk about. So I've opened up the chat there. If you've got any topics for conversation, any questions or issues, please let me know. If we've got time, there's something I want to explore in connection with an email that I got yesterday, which was quite bizarre. Anyway, so topics for today. First of all, transfers of beneficial interests. I think I've mentioned to you, I think you will have recalled the case of Hathaway and the house, which I think was a lovely name, called Picnic House, and the transfer of beneficial interest via exchange of email. Have you all seen that case? Really interesting. It's sort of an exploration of Section 53 of the Law Property Act 1925 and how a beneficial interest can be transferred. And of course, it can be transferred simply by writing. And the Hathaway case was looking at an exchange of emails. And the decision of the court was that an exchange of emails was sufficient to transfer the beneficial interest of Picnic House from Party A to Party B. Well, that sort of line of argument, that sort of line of reasoning was then taken up in a recent case where there was an exchange of WhatsApp messages. And it seems that the law is prepared to move, but move rather slowly. In this recent case, the court said WhatsApp messages aren't like emails and aren't sufficient, or an exchange of WhatsApp messages is not sufficient to transfer a beneficial interest from one beneficial interest owner to another. It's a really interesting area, isn't it, this issue about the significance of emails, etc. If you're interested about electronic signatures and all that goes with it, can I direct you to the City of London Law Society's Land Law Subcommittee website, which has interesting guidance on the use of electronic signatures, etc. It's slowly creeping into practice that electronic signatures are being used, and I don't think it'll be long before electronic signatures are the norm, to be honest with you. That was the first thing I wanted to talk about. The next thing, I'm getting lots and lots of questions about the revised TA6 as sort of March is looming, as March sort of gets nearer and nearer. The website, which one, Michaela? Have a link to that website, please. Yeah, just remind me, Michaela, in the chat, and I'll come back to you on it. Oh, for electronic signatures, yeah. Sorry, City of London Law Society, Michaela, Land Law Subcommittee. It's free to access, and there's lots of useful stuff on there. If you haven't seen it, have a look at it. There's a protocol for the use of electronic signatures. The site is predominantly for commercial property lawyers and the city firms, etc., Michaela, but often they'll come up with stuff that's sort of pretty advanced, as it were, or pretty ahead of the curve. I remember, when COVID hit, there were protocols that were used on the City of London Law Society website that were put into practice generally, really. So it's some interesting stuff there. Sorry about that. Yeah. So the revised TA6. Have you all read the revised TA6 form and the explanatory notes? Okay. I've sort of digested them, dissected them, looked at them, and I'm a bit worried, to be honest with you. And the reason I'm worried is this. Traditionally, with regard to a TA6 or a TA7 form, if I'm acting for a seller, if you're acting for the seller, you give the client the form, you warn the client about the dangers of completing the answers to the questions incorrectly. You indicate the warnings that are on the form, and you say to your clients, answer the questions truthfully and honestly. Hopefully, you say to the client in the retainer or in the email where you send the forms out to the client, or the letter where you're sending the forms out to the client, you say, my role is simply to check what you say against information which I hold on file. I'm not to give you any advice concerning the questions or your answers, and I can't answer the questions for you. Okay? So the rationale behind the old TA6 and indeed the old TA7 was that the client fills them in, send them to you, you have a look. If the answers are consistent with what you've got on your sale file with regard to title, etc., off they go to the buyer's solicitors. If you look at the revised TA6 and the explanatory notes, one, there's a number of new questions that the sellers are being asked to answer. And two, in the explanatory notes, there's two things that immediately burst out. Number one, that clients are told that before answering questions, they should make reasonable inquiries before answering. And number two, on a number of the questions, the client is told, if you don't know, consult your solicitor. So, for example, one of the questions asks about irregular boundaries. Is your property bounded by irregular boundaries? And in the explanatory notes, it says, if you're not sure about what an explanatory irregular boundary is, or consult your solicitor. Now, all right, I'm your client, okay? First of all, what's an irregular boundary? Well, I guess anything other than a straight line, but is that right? Could it be a situation where it appears to be a straight line, but then the neighbour and I have been discussing that perhaps it isn't, perhaps the straight line, the fence line or whatever is wrong? Does that mean it's irregular? So there's an issue there. And then what happens if I say, right, help me? The explanatory notes say, if I've got an irregular boundary, I need you to assist. So what are you going to say to me? Well, you're going to say to me, I hope, Ian, yes, you've got an irregular boundary. You certainly can't advise where the boundary is. Okay, the legal boundary going to be an issue. So I think that's unfair, right? And what worries me is I'm going to ring you or email you. You're busy with someone else, something else, right? And I say, how do I answer this question, or what do I say? And there is a danger that you then tell me what to say. Okay. And if you do that and you get it wrong, one, I'll be sued for misrepresentation potentially. And in those circumstances, I'm going to say, well, you advised me what to say, and therefore you're in the firing line for a negligence claim. Okay. There's another question about have you received any notifications, etc., in connection with neighbouring properties? No, nearby properties. Okay. So what's a nearby property, Joe? You and I, and thanks, Joe, for the note. You and I could sit down and I could say a nearby property is something 5 doors either side of me on either side of the road. And you could say, well, hang on, Ian, no, that's not right. I would regard a nearby property as anything within 200 meters. And then we could have Michaela saying something else. So, all of these things worry me. It worries me even more because of some of the things we've looked at in the past. Remember the 2 cases that we looked at, the Woodward Fisher case and the closed moths, and the other case that we looked at, the Welsh case concerning the skylight window, Rosser and Pacifico. Skip my mind for a moment there. Remember those 2 cases, okay? Sellers are being sued for misrepresentation, important point number 1. Important point number 2, the courts are emphasizing that, the significance and importance of the seller answering the TA forms and the buyer relying on the TA forms. And for misrepresentation, the test for inducement isn't particularly high. So all of these things, I think, are going to create a perfect storm. And what worries me is we're now going to have clients who think, with regard to TA forms, our lawyer, our solicitor, our conveyancer can help us in answering the questions or providing an explanation or giving us advice. Problem number 1. Problem number 2, the seller being sued for misrepresentation where the reply or the information that's provided is incorrect. Particularly where the courts are saying if there's a wide-ranging question, it warrants a wide-ranging answer. So we've got to be really careful about what we say to sellers. The explanatory notes also require us to make sure that the buyer is aware that they're under an obligation to notify us of any communication that they receive from any third party relating to the property they're buying, out with the responses to the TA forms. So again, the buyer's now under an obligation to let us know if, for example, the estate agent provides a copy of an old planning permission or some drawings that were done with regard to a home extension or something of that nature. So that worries me a bit. So in short, what I'm saying is, if you haven't already, have a look at the documentation. and have a look at your retainer when you're acting on a sale or purchase, so that you are ensuring the client understands what it means where you're being asked for guidance. And what I will be doing is emphasizing that I am assisting you in understanding the question and assisting you in general terms as to what the question is looking for, but I'm not answering the question for you, nor can I give you advice as to how the question should be answered, unless what you're saying is contrary to what I can see on your conveyancing file. I think we've got to be very cute with regard to how we deal with this. And I think we've got to make sure that our colleagues, and particularly junior members of staff, aren't sort of put in the difficult position of a client emailing saying, I've got the form in front of me, how do I answer this question? Okay, there is a danger in that situation, given time pressures and all the constraints, that we say, look, this is what you say. Okay, and that's what happened in the Woodward Fisher case. Remember, additional inquiries raised by the buyers, sellers and buyers and seller solicitors get together and say, how do we answer these questions? Seller solicitor, in essence, drafts legalistic types of reply. And then what you've got is a situation where the seller is sued. Seller solicitor says, well, hang on a minute, I answered these questions, but I wasn't fully au fait about just what an extensive problem there was with regard to close moths. The seller didn't tell me all about that when I drafted the reply. So you can see a bit of a spat and potentially a defence for the seller solicitors if they're sued in negligence as a consequence of Mr. and Mrs. Woodward Fisher successfully being sued in connection with misrepresentation. So going back to Joe's point, you haven't seen them. New forms are restricted to Law Society subscribers. Yeah, you can download them, Joe. I think they are available. I think search providers are carrying them now, but you can get them on the Law Society website. If you haven't, let me know. I can send them across to you. The questions themselves are, all right, they're a bit more wide-ranging than before. It's the explanatory notes in conjunction with the questions that trouble me a little bit because of this sort of change in role, really, as far as the seller solicitor is concerned. That's the thing that gets me, Joe. And if you're CQS compliant, Joe, you have to use them as of the end of March. But I'm encountering firms at the moment who are saying, well, we're not using them, but we're getting seller solicitors that are producing the revised TA6 in the contract pack. So again, be alive to it. Next thing, Robert. Hi, Robert. Good afternoon to you. Service charge question. Yeah, they haven't. Well, Joe just pinged me an email. I'll send them across. I've got them somewhere on my system. Right, converting old wooden office buildings for sale as opposed for rental as residential use and terms may not be appropriate. These old offices, in most cases, are these 30 years old. The buildings were never constructed if inside the main concrete and other structure will start to fail, because the liability for these is to be expensive. Repairs will fall on the flat owners. Well, right, great. Robert, you raised some really interesting questions there about the Building Safety Act. Okay. Number one, about the Building Safety Act, I'm seeing more and more inquiries, more and more problems, not from our residential colleagues, although there still are questions and problems for residential colleagues, but I'm seeing commercial property lawyers encountering problems because they don't appreciate that a mixed-use building falls within the concept of a high-risk building or a relevant building for Building Safety Act purposes. Going into a deeper dive in your point, Robert, there's a number of things with regard to these older office buildings that are being converted into resi. One, lifespan issues, structural beams, etc., are building safety risks for the purposes of the Building Safety Act. Remember, building safety risks associated with the spread of fire, etc., but building safety risks also associated with the risk of collapse of the building. So, Robert, when you start talking about structural beams and other structural elements failing, that's caught by the Building Safety Act. Okay, now, a few things. If that is the case, first of all, we've got to make sure that we fall within the criteria of a relevant building or a higher risk building before the Building Safety Act bites and protects leaseholders. Point number one. Point number two, if the building is a relevant building, more than 5 stories or 11 meters in height, containing 2 residential dwellings, then the position is that Schedule 8 will provide protection. It provides protection in connection with certain types of building safety defect. Its maximum scope for protection applies to residential leaseholders who own qualifying leases. However, where works were done by a landlord or building owner or associate of a building owner, then as long as the lease concerned predates the 14th of February 2022, any leaseholder, including a commercial tenant or a residential leaseholder, even where their lease is non-qualifying, would be protected, and a landlord would not be able to transmit remediation costs for such defects into their service charge. I repeat this, provided the original works were done by the landlord or an associate of the landlord, and provided those works were undertaken in a period of 30 years between going back from June 2022. Okay, Zara, thank you very much about the help for Joe with regard to InfoTrack. Okay, so Robert, yeah, you've got to be careful with mixed-use buildings. Okay, residential units on traditional long-term leases might not be appropriate. The BSA would only apply, Robert, and Schedule 8 of the Building Safety Act would only apply if you acquired a residential long lease that included a variable service charge. So very interesting point. And yeah, this conversion of office accommodation into a resi, the planners quite like, but it generates issues. The other thing I would say there, Robert, which is sort of a slightly off on a tangent, I'm doing quite a lot of work with regard to high street rental auctions. Have you seen those, Robert? This idea that local authorities can now regulate commercial tenancies in sort of high street locations where the high street is sort of in decline and units haven't been let for a period of over a year. The high street rental auction system allows the local authority to designate an area, a high street rental auction area, and then designate buildings or parts of the building as suitable for the process. And if that's the case, the local authority then takes over control of finding tenants, etc. Not relevant as far as today's concerned, but a sort of variation on the theme. Great. Okay. Thanks for that, Robert. So just watch the revised TA6, the revised TA7, have a look at your retainer. If you're acting for a buyer, have a look at your report on title and just make sure you're compliant with the explanatory notes. The next thing, car parking and easements. Just be careful about the right to park cars. The right to park cars can be an easement, but of course, to be an easement, the owner of the servient land has to retain a degree of control over the land over which the easement runs. So if you have a situation where there is exclusivity in favour of a leaseholder with regard to a car parking space, there's an argument that that's not an easement. I was just looking at easements generally this morning and yesterday, and about the fact that the concept of an easement is not a sort of closed book. The courts are always willing to look at expanding what an easement is. Circumstances where that expansion has failed were the sort of rights to a view types of argument. The right to park cars, I think, is now accepted as being an easement in law. The right of storage has been recognised as an easement. The right of enjoyment, I can't remember the name of the case I was looking at. There's a case involving, gosh, I think it was a sort of a resort or something, and the right to use facilities. And I think the Supreme Court said the right to use those facilities could be an easement. I can't remember. That's bad, isn't it? Shows you I'm going around the bend. I was reading a case last night about that. It was an article, I think on Falcon Chambers website it was, about that. It was interesting. Yeah, so car parking, just be careful, right? A few points really. One, if you have a right of way for vehicles, but no parking facilities on the dominant land, then a right of way can include the right to park on the way as long as you don't obstruct it. And the other issue with regard to car parking is that, of course, the recent law relating to car parking involved the case of Moncrief and Jameson, which was a Scottish case that ended up in the House of Lords. I think it's quite ironic that you'd imagine that the leading case on car parking would take place in the most heavily congested area of the UK, central London, central Birmingham. But no, the law relating to car parking and easements relates to a case in probably the most remote part of the United Kingdom. I think it was the Shetland Islands, and a right of way across a croft to the top of a cliff with a house at the bottom of the cliff that had the benefit of a right of way but no parking facilities. Don't know if you've read Moncrief and Jameson. It's a really interesting case. There's a barrister called Ian Mitchell at Tanfield Chambers. Ian's dual qualified. Great guy as well, really interesting guy. He speaks at some of our conferences. He was the lead counsel, I think, on Moncrief and Jameson, so he's got some interesting tales to tell about it. But watch your car parking. The other point with car parking and easements, car parking and leases. Car parking spaces not being shown on plans or not being referred to as being part of the demise, or easements not being properly configured or not being properly included at LR11 of the prescribed clauses. All of these things can cause issues and can cause problems. As a landlord or as an owner of servient land creating easements relating to car parking, what I would venture to suggest is that you should ensure that the owner of the servient land has the obligation to repair and maintain, retains the airspace above the car parking space for development purposes, and also reserves the right to allocate alternative bays within a car parking area. That sort of thing would mean that the servient owner would still have a degree of control over the land, and therefore you've got a greater chance of the court being willing to accept that it is an easement. With easements generally, always remember to watch out for repair and maintenance issues. They should always be dealt with expressly. If not, then you fall back on a case called Carter against Quayle. I don't know if you've seen it, where the court, I think it was a High Court decision, reiterated the sort of basic common law principles with regard to repair and maintenance. That case, Carter and Quayle, was mentioned in the article I've just referred to at Falcon Chambers, which I was looking at yesterday. I had a great day yesterday doing some in-house training for a firm, and we were talking about all sorts of different things that are causing them headaches and problems. One of those things being cryptocurrency and the provision of cryptocurrency as a method of funding and conveyancing transaction. And the general consensus around the table yesterday is that cryptocurrency as a means of investment is sort of moderately commonplace these days. And it's somewhat a mismatch in that, as transactional property lawyers, the vast majority of conveyancers are unable and unwilling to accept cryptocurrency as a source of funds. The reason for that is that you've got to chase down the money to see where the initial investment came from. So we're talking about source of funds with regard to that. Then we've got to be careful about what the cryptocurrency is and where it's held. There's jurisdictional issues and potentially sanction issues with regard to that. There's then, well, that's the point, Anthony. It potentially is, a license or something of that nature. Okay, that would be the issue. So good point, Anthony. Anyway, going back to cryptocurrency. So then what the sticking point, the real sticking point is, if you invested £10,000 in cryptocurrency 4 years ago, and I don't know, but let me guess, it creates, you buy 3 Bitcoin, I don't know what they're valued out there, 3 Bitcoin, all right? And today that £10,000 investment is worth £150,000. How has that £10,000 grown into £150,000? Interesting one, isn't it? So you'd have to have some form of evidence to show that increase in value. And then you've got problems with crypto wallets. So when funds are transferred in and transferred out of a cryptocurrency, are they in and out of a crypto wallet? In which case you've got jurisdictional and sanction issues potentially appertaining to those wallets. You know, if the wallet is created by an entity in Russia, or I've seen one with North Korea, well, we've got massive problems in those circumstances. So a lot of firms just saying we can't deal with it. National Crime Agency saying don't deal with it. Law Society and the professional bodies saying the same thing. So again, just be careful. Flowing on from that, which arose yesterday, which is really interesting. Yeah, Joe, an equitable easement, perhaps. Yeah, in which case it would have to be noted on the title, wouldn't it? Would be the argument there, Joe. Perhaps. But then, so going back to cryptocurrency, right? This is where it got really interesting. Question that was put to me was this: client contacts you and says, I'm buying a property. Okay, you've asked about source of funds. I've recently been married, okay, in Romania, and the tradition is in Romania, at the wedding, guests of the wedding give the bride and groom cash. Okay, so I got X $1,000 or euros or whatever the currency in Romania may be. I got £20,000, or my partner and I got £20,000 as, in essence, some form of dowry. Okay, I put that into my Barclays bank account when I got back, or I put it into my Metro Bank when I got back to London. Okay, so then what do you do? We were discussing this and say, well, all right, there's an issue here. Okay, this could be a wheeze, couldn't it? You know, the Romanian mafia, if there is such a thing, could be washing money through Barclays Bank and through our client account. So what do you do? So what we thought was, well, one, can you prove that there was a wedding in Romania? Wedding invitations, or however it's done on Facebook or WhatsApp or whatever people do these days. Okay. Number two, could you get a letter or some form of proof from someone at the wedding to say, yes, I attended the wedding and I gave Brenda and Jonathan, good Romanian names, $500 or whatever currency it was, and I saw other people doing something similar. Is that enough? Okay, do I have to speak to the attendees, the guests at the wedding, to verify that? Surely I don't have to trace everyone to get the, so I can, you know, so and so gave 500. Great aunt Samantha gave, you know, 2,500. I surely don't have to do that. It would just have to be a flavour of who was there and who gave what. But you see the problem, okay? And again, you know, with Indian weddings, etc., not an uncommon thing to happen. And then how far do you go with regard to that cash? Because as I say, you know, it could the whole thing, the whole scheme could be a massive sort of money laundering scam. Okay, and if it is a massive money laundering scam, it's not beyond the wit of man to have you know, wedding invitations, to have elderly relatives all across the world emailing to say, yes, we were there, and yes, we did this, that, and the other. So a problem, isn't it? Real problem. Again, the issue there is what's reasonable in my view, but we've got to be careful. But it is an opportunity, isn't it? It's an opportunity, is the point I'm making. Right. Next thing I've got on my list, and remember, it's, you know, I think someone's title, where's you laugh at this, I think it was Mr. Stephen Smith, describes my talking at presentations, webinars, forums as droning on. So to stop me droning on, if anyone has anything that they want to put in the chat, put them in there and we'll talk about them. But meanwhile, the next thing I've got on my list, artificial intelligence. Every day, firms are talking to me about the fact that they're submitting reports on title to clients, and clients are putting the report on title through AI and coming up with questions, queries, issues. And the question there is, I think that's now a fact of life. Okay, someone told me, and I thought this was quite interesting, that what they do is they put to AI what the client has sent to them via AI. So we've got AI talking to one another, which is fascinating. On a serious note, we've got to be careful about how we use AI. If we've got to have a firm policy, number one, as to what we're doing with AI, and everyone must adhere to it. We might allow it in connection with, sort of general guidance, etc. But then there needs to be checks, measures, and balances with regard to its use. I'll come back to you, Zara, in a moment or two. And if we are using AI, there's issues with regard to client data and client confidentiality. And therefore, we've got to be careful about what form of AI we're using. Is the data that we're giving AI kept in a silo? Because one of the things that I look at with regard to AI is that it gets better because it learns, and it learns due to the more exposure it gets to information. So if we're in a situation where we're not sharing all our client data with AI, does that to an extent constrain how AI learns? But if we do allow AI to use all the data, then does that mean we've got a client confidentiality and data issue? So I'm not quite sure how we're going to do that. So it's interesting, isn't it? Okay. AI is there's no doubt in my mind, AI is going to assist us with regard to the conveyancing process. I think at some point, AI is going to be used to sort of rewrite the conveyancing process. That's going to be interesting. I'm doing a project at the moment where AI has been utilized to provide risk assessments in connection with the entirety of the conveyancing process from the perspective of clients as well as estate agents, conveyancers, etc. And it's really interesting. It's not the finished article by any means, but there's some really interesting things that it throws up that perhaps I hadn't contemplated. Yeah, let's just look at this for a moment. Okay, Zara, 4 pages of questions from the client. And yeah, you should be charging for it. Okay, again, what I would suggest is you say in the retainer that if the client uses AI to generate questions or queries or require further information, that you're happy to attend to it, but that you would charge extra. Yeah, and I think Laura's idea might be an idea. Joe, I would say only something that's already available in public form could be shared with AI. Yeah, I think that's right. Unless Joe, your client allows it. Are you with me? So I think you've got to have an AI policy as a firm. I think you've got to share that AI policy with your client. And I think the client needs to have a right of veto with regard to its use concerning their information. So really interesting stuff, isn't it? And I think it's just going to get more and more interesting. Some would say more and more scary. Right. Zara, just said the client that clearly hadn't read it as they explain the risk of enforceability. So, Zara, this was something again that we talked about yesterday, the enforceability of covenants, right? Again, I bleat on about this, right? I worry when people submit a report on title to the client and they say, the property you're purchasing is burdened by restrictive covenants. Here's a list. And all the conveyancer or solicitor has done is looked at the title and seen a list of restrictive covenants and regurgitated that list. And the point, I'm not bothered about that, but what worries me is the fact that you're saying the property is burdened by these restrictive covenants. It may be. It may not be. The land registry listing restrictive covenants on a title or referring to their existence in a conveyance or transfer or something of that nature is not validating or legitimizing the restrictive covenant. It's just saying someone's applied to protect the covenant by noting it on a title. Here you are. So I'd much rather conveyancers say, your property appears to be burdened by restrictive covenants. Here's a list. But I haven't investigated their enforceability. And that then takes me to the point that Zara's saying there about explanation of enforceability of covenant. Where I've got covenants that are going to impact on client objective, or where client says, oh, I'm concerned about that, then what do we do? And I think we can investigate enforceability as long as we don't do anything that would constitute disclosure and invalidate any insurance policy. Where our investigations don't determine one way or another if a covenant's enforceable or not, then I think we turn to a defective title insurance policy. However, the point I would make is there'll be some restrictive covenants that I would say you don't need to investigate enforceability. So going back to Zara's point, Zara, I'm your client, right? You've sent me a list of restrictive covenants. There's a restrictive covenant 1898 preventing the manufacture or sale of alcohol. And I'm buying number 2 Westgate Mews, Colchester. Okay. That covenant isn't going to bother me. It's not going to affect marketability either, is it really? So I think in those circumstances, you just say to the client, there are restrictive covenants. Here's a list of them. I haven't investigated enforceability, but given your objective, given this is a residential property, it's not my intention to carry out any investigative work. If, however, there's a restrictive covenant that was created in 2003 that restricts trade or business activity from the property, and the client's told you he wants to use the property as a workshop for his electrical business or a home office or something of that nature, then that would be a different matter. Okay, I'm just going to have a look at the chat again for a second. Yeah, inquiries raised by buyers, solicitors, Vanessa. Thank you for that, which appear to be generated by AI. It happens as well, doesn't it? Okay. Additional inquiries, Vanessa. My starting point is conveyancing protocol. Generic inquiries I'm not obliged to answer. I would be obliged to answer questions that are raised by the buyer directly or raised by the buyer, solicitors or conveyancers on the basis that the information I've produced in the contract pack is incomplete or vague or ambiguous. So you might be able to say, Vanessa, if we are dealing with the transaction to which the CQS relates, that if the inquiries are generated, the client would have to, the buyer's conveyancer would have to verify that the inquiries have been generated by them or their client and not by AI. But really good question. But you're right as well. As AI gains in sophistication, the chances of your spotting that it's AI generated will increase, because you can ask AI to write a report or a letter or an email in your style. Is everyone aware of that? I found that out from Richard Susskind, who asked AI to write a letter of condolence to a friend of his whose father had died. And what Richard said was the letter of condolence was far better than anything he'd received in the past when he'd had unfortunate bereavements. Yeah, so it's interesting, isn't it? Interesting stuff. All right, so Zara's come back to me. 1934, asking for consent for altering the building. Yeah, got you. Okay, I tried asking chat. Hi, Ellen. To write my report based on something. Good job until it was a complete made it clear. Ellen, you can't. It's like, I would say, it's like giving the task to a trainee in during their induction week. You're very brave if you say get on with it, and you're very foolish if you just send it off to the client or the other side without first having checked it very carefully. Robert, yeah, it's for the same use. So it's intention to develop a change US specialist insurance required. Thanks for that, Robert. That's great. Really useful. So we've talked about that a bit. Interesting. Tax advisor and SDLT. Where are we with this, everybody? As yet, I haven't got a definitive answer of where we are with this. I think it's still going backwards and forwards from Law Society, HMRC, and everybody else, isn't it? Seems to me. The thing that worries me is that if we register as a tax advisor, as we appear to be compelled to do, how do we then get away with saying to the client that we're not a tax advisor for tax purposes? Because if I'm a client, I'm going to look and say, well, hang on, you're registered as a tax advisor, but you're telling me you're not going to give me tax advice. So like I was saying with the TA forms, we've got this sort of mixed message that is going to be confusion. And the thing that really worries me is if we drill down on this, if what we're doing is vague or ambiguous, our retainer, for example, it's going to be construed against us. So if we say in our retainer, we're not a tax advisor, but we are registered as a tax advisor, and the client's on the warpath with regard to potential negligence claim with regard to tax advice, and we say, well, in the retainer, we said we're not, the client's going to say, well, you are, because you said you were. And, what's a court stance going to be? Yeah, it is, isn't it? But I think it's the FCA, isn't it, that's sort of pushing this forward, Zara, right? And I've been talking to a number of firms, and some of them are saying, well, we're going to register, but we're going to firm up our retainer. Well, I'm interested in what that firming up entails. Or some firms are saying, well, we're not going to do it. We're not going to submit the form on behalf of the client. And I say, well, hang on, if you do that, you've got a major problem, because what about your lender and protecting your lender? Thanks, Tony. Anthony Rob, HMRC updated guide to today's conveyancing LinkedIn yesterday. Didn't have a chance to read it, but I have taken a picture of it and we'll read it at some point at the weekend. But it's interesting stuff, isn't it? Okay, really interesting stuff. The next topic I've got on my list is undertakings and risk assessment and the tragedy that's happened to PM Law. I think this just brings into focus the fact that the conveyancing process is entirely dependent on trust and entirely dependent on an ability to accept an undertaking and know the undertaking is going to be complied with. So first of all, anyone got any transactions that they're dealing with that's caught by this current really sad situation with regard to PM Law? It is PM Law, isn't it, by the way? I'm sure it is. So I've said to practitioners for a number of years, really, and what worries me is, in assessing risk, okay, how far do we go? Because, I'm fairly confident no one, before what we heard of on the 2nd of February, would have thought that PM Law was high risk, or their various trading names were high risk. In fact, if anything, you'd think, well, because of the umbrella organization, an assumption that there's better compliance, better in-house sort of management, etc., structure, that there's less risk. Yeah. So what do we do? In the past, what I've said is, if the amount required to redeem the mortgage, so the sort of £1 million houses, if that exceeds the firm's professional indemnity cover, then you'd want additional protection. You might want a situation where you say, well, look, no, I'll pay over the money to the building society, etc. But all of this sort of leaves in tatters the conveyancing protocol, doesn't it, and CQS and all that goes with it. Yeah. So nightmare. And a TR1 post-completion. Yeah, there's all sorts of things I hear on the grapevine, Sarah, about, the mess, as it were. And the thing that gets me is there's probably, it's sad. Of course it's sad for everyone that worked for PM Law and associated with it. I get that. And it's sad for the clients. But what's also sad is the fact that there are conveyancers on the other side of these transactions who I guess are getting grief. If I'm a lay client and I was due to complete when, 6th or 7th of February, and I can't, okay? And I know Gordon's, who are the agents for the SRA, are doing their best, etc. But, you know, stuff still, as I understand it, is in transit or not resolved as yet. I'm going to be on the warpath to you, aren't I? So there, you know, there you are. Amanda sort of raises the point. So surely, Amanda, your sort of faith in the conveyancing process is sort of not shattered, but cracked, can I say? Okay, you know, hang on a minute, you know, the doomsday scenarios happened and the fallout is quite catastrophic. And how long is it going to take all of these transactions to get back on the road again? I'll leave that at that. Anyone got any comments? Yeah. Yeah, well, that's right. Market forces are such, Zara, that hopefully people aren't going to sell elsewhere. So you could be right on that one. Yeah, it is. My heart goes out to them, you know. Just horrible, and horrible for the profession as well, isn't it? I mean, you know, just at a time when we could probably do without flack, we're probably getting it. But good to hear, Joe, that you've done that. That's good news, I suppose. Right, acting on sales and purchase of buy-to-let properties, renters' rights, okay? Alarm bells, please. Just be aware, if you're doing a lot of work for buy-to-let investors, get to grips with what the Renters' Rights Act is doing with regard to notices that have to be given to existing tenants about the demise of the assured short-hold tenancy, the creation of the assured periodic tenancy, restrictions on advance payments with regard to rent, rent reviews, etc. And watch out for lenders' instructions changing. What lenders who are lending in the buy-to-let market are doing at the moment is having a real hard look at their underwriting, because the Renters' Rights Act, great news for tenants, potentially bad news for landlords with regard to revenue, income stream, etc. So there's going to be some fallout there, I think. And also, if anyone's doing a lot of work for clients who have student lets, and again, you know, university town, Durham up here, Exeter, or, you know, wherever you may go, if you've got clients that have got lots of student lets, there's some quite significant changes, courtesy of the Renters' Rights Act, to student lettings. In particular, there's a new ground for possession, I think it's 4A, that allows possession between May and September to try and open up the lettings market for new students, etc. So watch out for that. I mean, I think the key date is the 1st of May, isn't it? 2026. The good news about the Renters' Rights Act is that the assured short-hold tenancy trap for residential long leases is gone. I think that went on 27th of December of this year. But there's a bit of a state of flux with regard to private renting, courtesy of the Renters' Rights Act, that you need to watch out for. Yeah, okay, yeah. Rebuilding trust, and you can see it, can't you? Higher PI and compensation funds, contributions, etc. The other thing that gets me on that, you know, with regard to PM law, is we've got all these compliance issues, we've got all this regulation, all of this control, okay, and yet something like this still happens. You know, you think to yourself, well, what's the point, you know? Anyway, my last topic of the day, service charge issues in residential leaseholds. Loads of cases at the moment about service charge, first tier tribunal, upper tribunal stuff, and some points to sort of distill from the cases. Point number one, watch the lease to see how service charge is apportioned and how service charge is calculated. So we all get very excited about what services the landlord is obliged to provide and the ability of the landlord to recover the cost with regard to the provision of services. But there was a case recently where the argument was, what could the landlord recover from this particular leaseholder? This was a leaseholder in a block of flats. And you had service charge that related to services to that particular block. You had services that related to, I think it was described as the site, a number of blocks of varying heights, and then a service charge that related to development. And I assume the development included houses and commercial and whatever, okay? And the leaseholder is saying, I should only be paying service charge, that a share of the service charge should only relate to my building. And the court, upper tribunal, ultimately saying, well, no. If you look at the lease, it relates to the concept of the development. And I'm fairly sure that the solicitor acting on behalf of the leaseholder buyer and the leaseholder, when he read the lease, thought, well, the development, what's the development? And just assumed the development meant the building. So be careful with that. And again, we discussed this at length yesterday. Scope your retainer and leasehold transactions. I'm going to tell you how the service charge is to be apportioned as per the lease. There's no way of me actually checking that how it's actually apportioned with regard to the lease accords with what the lease provides for. I think there are some other issues there that, again, we explored yesterday. I can't advise you as to whether a reserve or sinking fund is adequate given the unusual items of outlay that a landlord could incur with regard to this building. So there's a few things that we can do in the retainer in a leasehold transaction that ensure the client understands that we're not in the frame if something goes wrong with regards to service charge or service charge apportionment. And then the fundamental point, which again, I always go on about it, but I think it's important. Clients need to understand that where on an assignment of a lease, 3-year service charge accounts are produced, or estimated accounts are produced, or projected accounts are produced, or whatever it might be, they are not indicators, they are not anything that can be utilized to restrict, limit, or cap future service charge. Cost of living rises, litigation that the landlord gets involved with, yes, the dreaded Building Safety Act, all of these things could mean drastic increases in service charge going forward. Service charge provisions in residential leases are contractual obligations on the part of the leaseholder to pay unascertained and unascertainable future expense going forward. So, what can you say to your client other than that? I was just looking at the new Law Society Conveyancing Handbook, and I was looking at what it said with regard to the role of the conveyancer with regard to service charge. And it did say, I'm just going to try and find it again, it did say that a conveyancer is required to advise on service charge accounts. I'm just going to try and dig it out again. It surprised me, to be honest with you, because I don't think it's something that a conveyancer should do. Right, where are we? just read it to you. Because I did some notes, and what I did was I looked at the statutory protection available for leaseholders, and then I looked at the Law Society Conveyancing Handbook on service charge, and I thought, oh, hang on a minute, there's an issue here. Report, can't find it. But it does say that you are required to advise on the service charge accounts. And I think what you need to do is you need to explain the limitations with regard to that advice. And I think all you're required to do is to look at the service charge provision within the lease. That's 1.9. See if I can find it for you. Yeah. Just say that. I'll dig it out for next time. Can't find it at the moment. But you are required to give advice to your clients concerning service charge accounts. And I don't think you can. That would be the point I would make. Right. Yes, Zara, again, important point you make about management companies. Your advice to anyone that's contemplating becoming an officer of a management company, don't personal liability in connection with contracts if these management companies insolvent, personal liability potentially under the Building Safety Act, etc., etc. Kate, well, only annual rent of 1, 2. Are we too concerned? No, not now, because of the Renters' Rights Act. I think the provision with regard to assured short-term tenancies changed for residential long leases on 27th of December 2025, I think. Yeah, Zara common hold, no requirement to consult. Don't have time to deal with common hold today. I've had a meeting with the government department about common hold, looked at the draft legislation, a few things. One, it means that ground rents, monetary ground rents for leases that predate 2022 are to be abolished. Forfeiture in residential long leases abolished. And it looks as if we're going to see common hold being introduced for new builds only, and then it being rolled out thereafter. We'll talk about that next time we can. Right. Yeah, there is an RICS service charge residential managing code, Zara. There's also a one for commercial service charge as well, Zara. You can have a look at. Ladies and gentlemen, it is after 1:30. I have to say, I absolutely adore these forums. I think they're really good fun. I have a real nightmare that I wanted to talk to people about, but I don't have time. We'll have a look at it next time. It's an old lease, a 500-year lease, and it's noted on a registered title. And basically, the land registry is saying, well, it can't be an absolute title. It can't be a qualified title. Basically, we don't know what it is, but it's sort of on the title. It's quite bizarre. So I wanted to talk to people about that. We're not going to have time today. And yeah, with common holds, the problem about a management company, a self-run management company, will still be a problem with regard to a common hold association. And my parting gift for the day, ladies and gentlemen, is common hold, and the introduction of common hold will not, if existing leases are converted to common hold, it will not make a ha'porth of difference to liability under the Building Safety Act. To finish today, anyone that's in the area of Newcastle or Manchester who have got conferences coming up, Resi in the morning, commercially in the afternoon, great fun, some great speakers too, and some fantastic sponsors. If you haven't had a look at legalmortgage.co.uk, it's our new website and newsletter, all about residential mortgages, commercial mortgages, lenders, lawyers, etc. Quite interesting, quite proud of it. And Property Law UK, again, very proud of that. Have a look at it, or if you want access to it, let me know. It's a subscription service. Legal mortgage is free, by the way. Property Law UK is at a cost. All I'd like to do is, first of all, thank you for attending. Laura, a pleasure as ever. To thank Wes for coming along. Wes, I hope it wasn't too much of a torture for you. Joe, always a pleasure to hear from you and to speak with you and to see you virtually. These events, okay, next time, send topics in. If you're looking at something on a file during the month, make a note of it and ping it across to him and say, can we talk about this next week? Tell colleagues about what we're doing. Put it on LinkedIn. The more the merrier for coming along, to be honest with you. I'll keep doing these as long as I can. Stewart Title will keep sponsoring them for as long as they can. As long as people like coming along, great. We also do one for support staff. We do one on the Building Safety Act. We do one on artificial intelligence, commercial property, local authority lawyers, all in very much a similar vein. Jane, everybody else, cheers, folks. Have a lovely week. When the weekend comes, enjoy it, and we'll speak soon. Thanks, everyone. Cheers, Jen. Thanks, everyone. Cheers, Jane. Thanks, Wes, Robert, Ali, Sandra, Zara, of course. Bye-bye. Take care.